Every state cheats. Very good, Kira. I'm sorry, Jenny. Jenny, you said that. Very good. Kira, was eminent domain discussed in this chapter? No, it was discussed in another chapter. Hi, Tim. I just had to let you know I passed. I'll be dropping off that bottle. Oh, Jermaine. Awesome. Excellent. Way to go, brother. Way to go. Good for you. Congratulations. Samuel, what was 8 and 9? 8 was D, 9 was C. All right. Why 11 is C and not B? 11 and not B. Well, first of all, he was incompetent, couldn't make out a will, and whatever will he made out, it was no good. Because of that, he died and was survived by his wife and 3 children. Therefore, there was no will, so B could not have been the answer, Viviana. All right, any other questions before we finish up with chapter 21? Six would be through eminent domain, correct? Yes, correct. All right, not seeing what makes a will incompetent. You'd have to talk to an attorney, Adeline. I am not an attorney and I can't give legal advice. I'm sorry. But you should talk to an attorney to find out what makes a will incompetent. The question, the premise of the question said this. Let me see if I can find it. An owner of real estate was adjudged legally incompetent. Not the will, the person was judged incompetent. That's all. All right, I think I cleared it up, so let's move on. Oh, right, there's the aha moment, right. All right, so keep looking for that money. It's out there, guys. Hope you played your Powerball. Oh, that was last night. No one won, right? And what's the next one? Megabucks? Yeah. Another $500 million running. All right, so Unit 21, public records, titles, and closings. At the end of this chapter, you should be able to explain New Jersey recording acts that establish a chain of title, evidence of title, and marketable title, as well as summarize the components of the closing process. So why do people research records, title searches? Why do they do that? To find out what the conditions are and the situation involved on property before you buy it. We would like to know that. So in order to look up property records in the public record, it must first be recorded in the public record. The public record, what is that? Well, first of all, under New Jersey's recording acts, we live in an open public record society. If records are recorded in the county courthouse records department, those are open for inspection by anyone who wishes to look. There is no rule about how you can qualify to look at public records. Anyone, and I do mean anyone, can walk into a records department. Here in Hackensack, it's the block south of me is the courthouse, 2 blocks south of me is the records hall. You would walk in, the clerk would say, how can I help you? Say, I'd like to look up property records. They say, there's a computer terminal, enter all your criteria in, and then it will tell you where those records in the physical storage departments are, so you can go and get them. And you can get photocopies of documents. You can keep them. You pay for them, obviously, if you have them photocopied. But those would serve as the record research that you do. So in New Jersey, all public records are open for public inspection without limit. Everybody's entitled to. Each county has their own record-keeping department. By recording something into the public record, you're giving legal, public, and what is known as constructive notice to the world of a thing happening. Constructive notice. Explain. So I buy a house. I have my deed recorded after it was acknowledged. So I sign the statement. The notary signs that they witnessed me signing it. That makes the deed eligible for recording. So I take my records, go down to the records department, hand them over to the clerk, and she tells me X amount of dollars for the fee, and I pay her the fee. She then gives me a time-stamped receipt of when she received those records. At that moment of the timestamp is when it is said that I gave constructive notice, because I gave it to the records department at that moment. That's important to remember for several reasons. So now that I've recorded my documents, what the clerk does is enters them into the public records by scanning them into the database, taking photographic or scanned digital imaging of the documents, then returns the original documents back to me after some time, usually like 2 to 3 weeks, it comes back to me. Stamped original. That way I have records of my property records as well as the public records has copy. Why is that important to do? There's 2 reasons. 1, giving constructive notice to the world that I bought the house. Number 2, what if I lose my documents? Then I can always go down to County Record Hall, have them print up duplicate originals, and those serve as original documents once again. You've done this probably with your birth certificate. Many times in job applications or passports or whatever, you're required to have a copy of your birth certificate, and you forgot, I don't know if I still have it. You can always go to the records department, have a duplicate original part printed up, and that serves as an original for you. So public records are for the public inspection by anyone, I said. Constructive notice is given to the world when a record is entered into the public records. Now, it is not required that property records be recorded for them to still be valid. A deed of conveyance is still a deed of conveyance and it's still valid, even if it's not recorded. It's still valid. It's just that you don't choose to give constructive notice to the world of the fact that you own property. You're an off-gridder. I don't care what you want to call yourself. The fact is, you still are the bona fide owner of property because of the deed that states it. By recording it, you give constructive notice to the world of the fact, but you don't have to. That's what I'm trying to say. You don't have to record your property records to make them valid. They're already valid. It's just that if you want, you can tell the world about it. And most people do. The reason is when you go to sell your house, the buyers usually do a title search of the property. If then they don't see that your records are on file, then they're going to come to you and say, do you have the records? You can produce the fact that you are the seller of property, and then you produce the records. Here's the problem, however. You didn't record your documents. Years go by, then it's time to sell the house, and now you can't find your documents. You lost them. Now there are no documents anywhere that prove you're the owner of the property. However, if you hire an attorney, he can forensically reconstruct all those documents from other public records like tax office records and other places. That's going to take time and money. Time you may not have if the buyer's in a hurry. Money you may not have because it costs a few shekels to do. The fact is he could forensically reconstruct that and then present those records as evidence of ownership. But by giving public notice, you're telling the world right away, I'm the owner of the property. And if anybody wants to look it up, go right ahead. You can prove I'm the owner of the property. It's on record. Huh. So they go to the county records department to find that out. Again, you don't have to record your documents, but it is strongly suggested to do so. Just for the mere fact, if you lose your property records or destroyed in a fire or damaged in some way, you can always get duplicate originals printed up again. So there is, however, a requirement for certain documents to be recorded, like mortgages. Remember, a mortgage records its interest to establish priority of interest. Who gets paid off first at a closing? So they want to make sure those documents are recorded so that when a closing occurs, there's notice that this one was recorded first, second, third, etc., and that's the order in which they get paid off. So again, in order to be recorded, the document must be acknowledged. Now, notice, I said constructive notice is given by entering these records into the public record. But you could also give notice through what is known as actual notice. Actual notice could be in writing. It could be a statement. It could be a telephone conversation. Or it could be the act of taking possession of something. Actual notice, when you buy a house and you go to the house, open the door, step inside, the moment your foot lands on the floor, cross that threshold and hit the floor, that's at that very moment you give actual notice of a taking of possession of the property. And your neighbors would come over and say, hey, let's have beer and discuss who you are, where you come from, and all the neighborhood ins and outs and all that other good stuff. Actual notice could be a statement or a dialogue you have with someone. Hey, Mom, know that house I was buying? I just closed on it 10 minutes ago. You just established actual notice. If you send a text or a phone call, you would have a timestamp to prove what that was. Now, here's a conundrum. At 9 o'clock this morning, I sold Viviana the house. As soon as the closing was over, at 10 o'clock, she went out to brunch, celebrated with a bottle of champagne, and then went to the records hall at 10:30 and recorded the deed into the public record and gave constructive notice. What Viviana doesn't know is that at 10:30, I met with Cynthia and sold her my property. She then meets her mom for breakfast and says, Mom, I just bought that house. Who's the owner of this property? Who's the bona fide owner of that property under that condition? Was it Viviana? Viviana says, yeah, it's me. Or was it Cynthia? Well, here's the problem, and it is. Who gave notice first? What do you mean? Well, what's the timestamp of the constructive notice versus what was the timestamp on Cynthia's notice to her mom, which was actual, Viviana's was constructive? Who gave notice first? Whoever's timestamp indicated they gave constructive or actual notice first is the bona fide owner of property. In this case, Cynthia told her mom at 10:31. Viviana recorded the document at 10:30. Viviana is the owner of the property. She gave constructive notice before Cynthia gave actual notice. But what if it was opposite? Cynthia gave actual notice to her mom at 10:30, then Viviana recorded her documents at 10:31. Then Cynthia would be the bona fide owner because she gave notice first, whether actual or constructive. This is maddening. Why do they have such rules? Because I didn't make them up. Somebody did. And that's what they built in. So whoever gives notice first has ownership of property, whether it's constructive or actual notice. Whoever gives notice first is the owner of the property. And I'm stirring up a hornet's nest, so I'm going to have to moderate and go back about 5 pages to find out where the conversation started. Okay, but the stamp from her mother's is verbal. Again, unless I texted her or called her, and in this case, I meant to say she may have called her to let her know before she met her. Either way, whoever had a timestamp to prove first recording is the bona fide owner. That's not legal? Yeah, of course it's illegal. I can't sell a property twice. There has to be some legal protection to this. Yeah, it's called the law. Both of them have to be recorded provable. No. Constructive must outweigh actual. Actual could outweigh constructive. Moral of the story is to go brunch and tell your mom and record your documents first before you go. She gave verbal notice to her mother. She's going to have a hard time proving that one again, unless she had a timestamp for a conversation. What? So wait, if Cynthia gave actual notice first, that is legal, legit? Yes. How do you prove that conversation? Again, we're going back and rehashing the same thing. So again, you probably asked these questions before I answered them. But again, in this case, it would have been through a telephone, text, or something that had a timestamp. But again, guys, please, let's not drift too far away from the idea of what we're trying to convey. So again, if there are there any other wrap-up questions to this? Because we do want to move on and get out of here at a reasonable time today. Because no, it is Thursday and tomorrow's Friday, the review. So technically, after you buy a house, you should go to the county clerk and give constructive notice, aka file the records. Correct, Kira. In fact, most attorneys who close real estate transactions and most title companies that close real estate transactions tell the buyers, for that small fee that you paid at closing, we are going to send a runner down and record those documents ASAP to prevent any problems from occurring. Then a runner goes down, hands over those documents, gets his timestamp, gives it back to the attorney, and then 3 weeks later, you get your documents in the mail. How often does it happen in New Jersey? Who knows? Who cares? I'm just telling you a scenario. There's no scientific records of these things that I know of, or crime statistics. I don't know. You don't have to do it personally. The attorneys and the title companies will do it for you. So Trinidad, can you cite me some sort of legal example or context of a legal precedent that says this is illegal? I'm going to tell you right now, of course it's illegal. I can't sell the same property twice in the same day. But I'm now sitting in Tahiti with a couple hundred G's in my bank account sipping umbrella drinks where you guys are going to battle out who's the owner back there in Jersey. Criminals don't care about the law. Okay, we're way off topic. Casina, good point. Why not give actual notice to the attorney? You could. That's the thing, guys. You could. I'm calling the cops. I'm taking you to court to give me my money back, Tim. Well, Ayana, first I have to get money, so first give me some money, then call the cops. All right, I do want to move on. Was there any other wrap-up questions before we move on? Samandia, did you have a question? I see your dialogue bar is open, so is Trinidad, so I'm waiting for your guys' questions. Or not. Trinidad, what's your final point? Because we do want to move on. Trinidad. Okay, guys, I can't wait forever. I do want to move on. All right. So constructive notice is given when recording documents. Actual notice is given by communication or taking possession of. What kind of documents are recorded? Deeds, mortgages, title insurance policies, title records are all recorded in the public record. However, we do not record sales contracts on properties. That's more personal information that the public doesn't need to know. In fact, the only people that are needing to know that are the participants in the transaction, the lawyers and the title companies and the state tax officials when they get a copy of your HUD-1 form to find out, did you pay the right amount of tax for us? That's the only people that need to know the sales contract. Now, chain of title. So you're going to buy property, or let's do it this way. We'll take the viewpoint of a realtor. Your client is buying property which you sold to them. One of the first things after attorney review ends is to have your clients do a title search of the public records. What happens is your client hires a title company and they send down an investigator into the county records department where the property is located. Now, that investigator is called an abstractor. And what the guy does, the investigator, he goes, looks in the public records for the public records on this property. He's going to pull up all those records for a side-by-side comparison to see. And what he's trying to establish is a minimum of 60 years of uninterrupted title ownership on the property. He'll see who the current owner is, and is that the guy you're buying it from? Yep, that's the current owner. Who was the owner before him? Did he buy it from? Oh, yep, he did, and go backwards of time. And if they can establish a minimum of 60 years of uninterrupted ownership history, it is said they have a clean chain of title. However, what if they determined that there's an ownership record missing because someone believed in not recording their ownership record? Then there is something called a cloud on the title, a missing ownership record. In order to proceed, your attorney is going to have to use a quitclaim deed in a suit to quiet title action, which creates an artificial link between the previous and after owners of the missing owner's record. It creates an artificial link in there. So that now you can say we have a 60-year uninterrupted ownership chain of title. Now that you've done that, the abstractor will write up something called an abstract. Now, the abstract is not a detailed record of the title records of the property ownership. It is a abridged version or a summarized version of all the important parts. So an abstract is a summary of the important parts of title ownership, and then that abstract is given to your attorney. Your attorney then, after reviewing it and agrees that it's a good record, will write his attorney's opinion of title. The abstract, along with the attorney's opinion of title, is one of the 4 evidences of title and can be used as good evidence that the person has the right to sell you the property. There are 4 evidences of title. 1 is the abstract and the attorney's opinion of title together. That's 1 evidence of title that you can use. The second one is if the current owner who's selling the property has title insurance on the property. Well, all they have to do is produce a title insurance policy, which is usually a recorded document. That alone is evidence of title. Because the title company sought to insure that property, they felt the evidence of title was strong enough that they would insure the property. Therefore, title insurance is evidence of good title. And those 2 methods, the abstract and the attorney's opinion, is 1 evidence, and the title insurance policy is the second evidence. Those are both used in New Jersey at any time. So now you have not just 1 but 2 evidences of title that say this is a good property to buy and there's a good record on it. There's a third one called a Torrens certificate. We do not use Torrens certificates in New Jersey. Usually that's done in very rural parts of the country where they don't have big county records department. In fact, you may be in the middle of who knows where, Utah, and there is no town for 50, 60 miles anywhere. Well, whatever the closest village is, then there may have a regional land office where the Torrens certificate is recorded, which is merely a statement from buyer, I sold it to this guy, he bought it from me, and they both signed, that's a torn certificate. It's not used in Jersey. It's used in very rural parts of the country. Don't ask me what states or where in states. I don't know. It's just a torn certificate. And the fourth one is called the certificate of title, which can be used in New Jersey. A certificate of title is where an attorney takes it upon his personal obligation to research the title records. Then when he determines that the title is good, he writes up the certificate of title, which is an attorney authorized letter, which carries quite a bit of weight and is a good evidence of title. So in New Jersey, we use abstract of title in the attorney's opinion, the seller's title insurance policy. Those are the two cheap ones we use. And in certain cases, a certificate of title can be used as well. So does anybody have any questions about what an abstract of title is or anything like that? Oops, Patrick has a question. And Sherry, so I'll wait. So we use abstract in New Jersey? Yes, abstract and an attorney opinion of title. How does someone know if they have title insurance? We're going to talk about that in a few minutes. There's usually a record recorded in the public record about that. Main difference between abstract and certificate of title. An abstract is an abstractor's report of title history along with the attorney's opinion of title is one evidence of title. We're going to talk about title insurance in just a minute. I just wanted to see if there's any questions about what we've talked about so far. How does an opinion of title differ from a certificate of title? An opinion of title is just that. The attorney reviews the abstract, says, in my opinion, this is a marketable title. A certificate of title is where the attorney actually does the research and forms an actual certificate stating this is the correct title of ownership proven through my research. It's not an opinion, it's a factual statement based on factual information. And Yenny Gonzalez, did you have a question? No? Okay, let me moderate and, oh, you did. So the abstract is more accurate and holds more strength. Well, the abstract, along with the attorney's opinion of title, is a very strong evidence of title and can be used as proof of ownership. Yes, it is one of the strongest there is. All right. So moving on. Talked about the four evidences. Now, marketable title. How do you know what you're buying is a good title? It's marketable. Well, first of all, is the title currently free from any significant defects? What are defects? Defects can be any encumbrances on the property. What's an encumbrance? Remember, we spent a whole day doing encumbrances. An encumbrance could be, but not limited to, easements, liens, licenses, deed restrictions, party wall agreements, encroachments. All kinds of things could be defects. So if you have too many of them, you may not have marketable title, because who wants to buy a property with all these encumbrances on it? Maybe no one. Therefore, when selling property, always ask the seller, what kind of encumbrances you have in the property? How many easements, if you have any licenses, restrictions, and all special assessments, unpaid, whatever. If those haven't been taken care of, then there could be significant defects in the title history, and the buyer doesn't want to buy it because I don't want to be subject to all those easements and liens and everything else. Of course not. Therefore, a marketable title is free from significant defects. Now, you can have a few, obviously, but significant means many and very strong ones. So, marketable title also assures that the buyer can buy a good title insurance policy to defend their interest in the property. Marketable title says the purchaser can be assured against having to defend against the title. However, it is also beneficial to get title insurance to make sure you're protected against claims. So let's talk about title insurance before we move on to closing processes. So here's a question, and I'm not going to open it up for discussion. I assume that if you drive a car, you have car insurance. Ooh, you got to have insurance in your car if you're going to drive it. If you don't, boy, what a risky proposition that is. In fact, if you can't prove that you have insurance on a car, you may have to get a ticket, be fined, and be cited, and your license may be subject to forfeiture because of that. So it's always important to carry car insurance on your vehicle when you're driving it. So when you pay for your car insurance, what are you paying for? You're paying in case something happens so you can be protected against an accident or something like that from occurring. You pay a premium at inception of the insurance policy, and then every year you have to keep paying that insurance premium to keep that policy in effect. Sometimes it's monthly or quarterly, but certainly every year you have to make sure those payments are made. So car insurance protects you against something that happens, and you pay for the policy over periods of time to keep it in effect. Title insurance is not exactly like car insurance, guys. First of all, you're not being protected against anything that can happen. You're being protected against anything that may have happened in the past. So in effect, title insurance protects the owner against previous claims to the property that they may not know about. So if an owner from 200 years ago of my property comes and claims against me about ownership, I better have title insurance to defend my claim? Yes, you better. Yes, you better. But really, who's going to come from 200 years ago? Well, there are certain property owners in some towns like Mahwah and other areas where indigenous tribes, Native Americans, are still claiming rights of ownership and suing property owners. And in some cases, title insurance policies are paying out claims to satisfy that Native American tribe. Whether that's right or wrong, I'm not a judge of that. I'm just saying this can happen and often does. Because, guys, we took land from the Native Americans. They didn't sell much of their property. It was taken from them. So understand, guys, there could still be problems from the past coming back to us today. What if a bank had a claim against property but never recorded their claim in the public record, and the seller sold the property, never paid the debt off, and here it is 50, 100 years later, and that bank is chasing the current owner for the outstanding balance on the debt. Could they go after the current owner? They do. Is the current owner obliged to pay that? I don't know. I'm not an attorney. However, it would be nice to have title insurance to defend me against any claims. Therefore, I could care less if a claim comes against me because my title insurance company is going to take care of it. So title insurance protects you against something that happened from the past. You pay your premium at closing, and that's it. You only pay premium once. And you pay per $1,000 of coverage. So if you're buying a current property of $500,000, you want to make sure you get a title insurance policy that covers you for $500,000 worth of claims. And remember this, yesterday's claims come in yesterday's dollars. So a mortgage amount on a property from 40 years ago may be for $5,000 to maybe $15,000. My property's insured for $500,000. Paid a claim, I still got $485,000 of coverage left. That's how it works. So before I move on, was there any questions about what title insurance is? Why would you buy without a clean title first? Well, because you don't know what may have happened in the past, Gary. That's why you buy title insurance. That's why you buy car insurance, because you don't know what's going to happen in the future. But you buy it anyway in case something happens. In this case, in case something happened that you didn't know about. So Andrina, I don't know what 4E23 means. Is that special code? Should I be flashing gang signs or something at the moment? I don't know. I've never been in that position before. Does adverse possession not apply with indigenous people? I couldn't tell you that. I don't know. But aren't you supposed to clear title before? Yes, that's why you do title search. But you know, some people don't, and they just buy property anyway, believe it or not. If a seller produces title insurance on the house you are buying from, then does the buyer still need to get? Yes. Is it necessary to buy title insurance? If you have a mortgage, yes. And I'm going to explain that in about 2 minutes. Is it mandatory or optional to buy title insurance? Again, I'm going to talk about that in about 2 minutes. How often is title insurance renewable? It's not. You pay for it once. It's good for the life of how long as you own the property. And if you pass it on as inheritance, the title insurance goes with the property to your heir. But if it goes to someone other than an heir, then they need new title insurance. Is that the only insurance property has? Or is that the only title purpose? No, you could buy all kinds of insurance for property. We're just talking about title insurance specific to ownership. Sounds like a bad attorney if they didn't pick up on clouds on title. Me, I would agree with you, Kara. All right, I do need to move on, guys, so hang on a second. So title insurance. Is it necessary? And the answer to your question is, if you have a mortgage on your property, yes, it is required by the mortgage company. But if you don't have a mortgage on your property, then it's not required. You have title insurance. It's that simple. Cash buyers don't have to get title insurance on property because they're paying cash. There's no mortgage. Now, let me back up for a second. If you are buying property and that requires a mortgage to purchase with, then your mortgage company wants to protect its investment. Therefore, the purchaser is required to carry what is known as a fee policy. The purchaser, the borrower who buys property, carries a fee policy for title insurance. It protects him against claims from the past. Mortgage companies are supposed to get an insurance policy called a mortgage insurance. It protects the mortgagee, the bank's interest against claims from the past. However, I'm going to tell you right now, banks don't buy policies. What they do is they tell the buyer, just name the bank as additionally insured on your fee policy, and we're covered if there's any claim, which they are. But only the borrower then pays a premium. The bank doesn't pay anything for the protection. It seems fair, but it is what it is. So now, because the bank has a financial claim or interest in that property, they want to make sure that their interest is protected through a title insurance policy in case a claim comes from a past debtor, owner, suitor, whatever you want to call it. Wow, so there's a lot to know about title insurance. Not really. It's just that a buyer must buy a known fee policy. A mortgage company gets a mortgage policy. It protects their interest should a claim come from the past. Now, one more thing. What does title insurance protect you about? Wow, that's a good question. What does it protect you against? Hang on a second. I'm going to look for my section on title insurance before I go any further. All right, so title insurance is just briefly given here. Title insurance protects you against any unknown defects of title ownership. Unrecorded debt may be protected. However, forgery is also a protected class. So if someone forged documents in the past, how can you be held liable for that? What title insurance won't cover you for are known defects, like a public right-of-way easement on your property that comes with the deed. Well, they can't protect you against any claim against your property coming from a public right-of-way access issue. You have to honor that. So they're not going to pay you a claim against that town exercising its right-of-way access. That's the way it is. What they won't protect you against is maybe, and I'll say this, maybe unrecorded debt and documents. Maybe, depends on severity of it. So your title insurance company is going to have a list of exclusions and exemptions under its policy. You don't need to know all about that to pass an exam. It's just that you have to know that title insurance is required when buying property with a mortgage. The buyer gets a fee policy. The seller, or the mortgage company, has a mortgage policy, and it protects you against claims from the past, and you pay your fee at closing, period. That's it. Now, you can get a new policy if you refinance the property. But again, it must be for the new refinanced amount or from the value of the property being recorded at the time of sale or refinance. So now that we've discussed that, we're going to move on now to closing the transaction. But before I do, does anybody have any left questions for discussion before I move on? Hopefully I answered your questions about when do you get title insurance and what does it do and all that other good stuff. Again, title insurance policies, I didn't say this, the policy rates are all set by the state. So the state determines how much title insurance is, and it's usually per $1,000 of purchase price. Let's put it this way. An average price home of $350,000 may have a premium of $1,500 to buy $350,000 worth of title insurance, somewhere around that, and then it goes up from there. So a buyer has title insurance and the fee policy is the title insurance, Kira. The fee policy is what the buyer purchases as title insurance. Can you explain again how the mortgage company gets around buying titles? Yes, instead of buying a mortgage policy to protect the bank, they tell the buyer, name the bank as additionally insured on your policy. That way, when you pay for it, we're covered as well for protection. Again, the fees are set by the state of New Jersey. I don't have a table of fees. You don't need to know that. If you buy a cash out, when you buy a house for cash, you don't need title insurance? Correct. You don't have to have it. What happens if someone comes and says the title is mine? Well, then you got a problem. You got to solve that out of your own pocket. So just because you don't have a mortgage doesn't mean you shouldn't get title insurance. In fact, if you pay for cash, you should. Because if you don't, then you have to settle the claim. You have to hire an attorney, go to court, and you may have to pay. It's just the way it is. All right. Was there any other question before we move on to finish up the chapter? What is the difference between fee and mortgage policy? Boy, oh boy, let me say it for like the 5th time now. The fee policy is the one the purchaser buys to protect them against claims on title. The mortgage policy is the one the bank buys to protect their interest if a claim comes against the title. Was there anybody else with a question before I'm ready to move on? I feel like should put on a replay, just constant replay here. If the mortgage is done through the same mortgage company that already has title insurance, do you still need new insurance? Sean, you can do whatever you want. However, the mortgage company is going to say, I don't care if you bought it from the same policy or not. You gotta have title insurance if you have a mortgage on the property. That's the requirement mortgage companies have. Pour me a shot, pour me 7 or 8 shots, Luciana. When a bank asks you to ask them, what? Oh, to add them. Oh boy, better check your keyboard. To refuse, you don't have to pay. Add them. When a bank asks you to add them, can you refuse? No, you gotta have protection. The bank will give you a mortgage if you don't give them a additionally insured. Was there anyone else? Some tequila shots. Let's move on. All right. Now, closing the real estate transaction. This is where you want to be in your career. Closing deals. Just as an aside, when I was at the height of my career, I was averaging 2 closings per week. In a calendar year, I had 100 closings. It's a lot of freaking business I was doing. Some of those were double-sided deals. Guys, the earning ceilings in the real estate business is unlimited. There is no ceiling as to what you can make. I'm going to tell you right now, if you have a heart for it, and if you have the guts for it, there's a killing to be made out there. Whether it's in residential or commercial, sales, rentals, whatever situation you find yourself in, there are always opportunities for business. The smart realtor looks for those opportunities in all markets. I've experienced many different aspects of the real estate business over my 27 years of career. I've tried different things, from residential sales and rentals to commercial sales and rentals to asset management to property management. I've done many of these things, and I was pretty good at them. There's many different ways to make money in the real estate business. However, I will say this, in any market that exists, in any market, there's opportunity, but you have to go dig it up and find it and capitalize on it before the next guy does. But when you do, you're going to start getting closings. The more closings that you have, the more money you're going to be making. So getting to the closing is where you want to be. Tell you the truth, guys, it's very nice to sit down at a closing table when they give you a check. You look at it and you go, especially when I was my own broker, that's all mine. Or I'm on a 50-50 split. So this check is made out to my broker, so I know I'm getting 50% of this check. Yeah, baby, that's my cut. You're going to make some money. But closing is very desirable to be at. So what happens at the closing? Well, first of all, at the closing, there's 2 closings. Most likely there's 2 closings on a real estate transaction. If you've ever bought a house, they usually told you, arrive at the office an hour or so early, because first you have to close on the mortgage loan. And then after that, you go into the next room and you close on the deed, the title ownership. So first you have to show up and sign a bazillion pieces of paper, go through 3 pens, have a spasm in your wrist after a while because you sign so many forms. And then once you finally sign those forms, you don't get a check. That's the most crazy thing. I'm signing all these forms to get a mortgage, and I don't get the money. The money goes directly to the attorney or the title company that's closing the property transaction. It goes into their trust account. Now, when I'm done with the mortgage closing, I get up and I go to the next room, sit down. Now we do the title closing, where the deed of conveyance of title rights is given to me, along with the keys, and the money from the mortgage gets given to the sellers. We shake hands, and the closing is done. So at a closing, the seller delivers good title, and the property must be delivered in the promised condition it should be delivered in. The buyer pays for the transaction through the funds from the mortgage company, or through cash, or all other sources of money that were deposited to go to the proceeds to the seller. Now, the lender has certain interests in a closing. They want to make sure that the seller, first of all, has homeowner's insurance up to the date of closing, and that the buyer has a homeowner's insurance policy for the property at closing. Why? Because something called risk of loss. If the day before the closing, the seller's property burns to the ground, well, he better have an insurance policy on that property to produce a settlement check to the buyer to build a new house on that property when he sells it. Or else the buyer could say, I'm not buying your pile of ashes for that kind of money unless you give me a new house or money to build a new house. They may just nullify the deal if there's no replacement. Therefore, it's imperative that insurance policies remain in effect until closing, and a buyer has an insurance policy on the property before the closing occurs. In New Jersey, there's additional requirements. Number one, carbon monoxide smoke detectors, fire extinguishers have to be in working order and checked off with a fire official signature. There must be a certificate of occupancy from the building department. If the property's in a flood zone, there must be flood insurance on the property. And by the way, flood insurance is not provided by the homeowner's insurance company. Flood insurance is usually through a specialty provider or the National Flood Insurance Program. It only covers water damage, does not cover storm damage, wind damage, tree limb damage. It only covers water damage. Flood maps are drawn up by FEMA, which is part of the Department of Homeland Security. So to define if a property is in a floodplain or not, you'd want to look on the FEMA website, enter your address, and find out if it's in a floodplain. Lenders must require flood insurance in areas of high risk of flooding, and it could be purchased by homeowners outside of flood areas for various reasons to protect against potential water damage. And rates can be lowered for flood insurance if your community practices the community rating system, CRS. When I was a councilman in Oakland, that's one of the things we instituted was the community rating system. The Ramapo River is notorious for flooding in some parts of Oakland. And because of that, flood insurance premiums are very high for those homeowners. By participating in a community rating system where the community takes certain practices under its wings, you can lower the cost of those insurance premiums to those individual homeowners. So if your community you live in is in a flood area and they don't do the CRS, as a good realtor, you may want to show up at a mayor and council meeting and suggest that the community may look into the community rating system to lower the flood insurance premiums that people are paying. You're going to look like a hero in no time at all by doing so. So unfortunately, it's time for our afternoon coffee break. So what I'm going to do is I'm going to leave the conversation open, and I'll return at 3 o'clock, and we'll finish up the day. So I'll see you guys at 3. Okay, 3 o'clock and it's time to get started again today. So let's moderate the conversation and move on. So flood insurance we were talking about and the community rating system. So here's the thing. There are programs available to communities that they can practice to prevent and mitigate some flood insurance issues in communities. And if they follow these practices, according to the community rating system, their flood insurance policy premiums per homeowner go down. And right now, in fact, they're still going up. So to get big reductions in flood insurance premiums are a huge benefit for your community. In fact, if you do this, there's usually a 30-day waiting period before anything happens. But again, it's usually a very good idea to have your community use the community rating system to lower the flood insurance premiums for homeowners. And sometimes cash buyers decide to get mortgages first and then pay them off after closing just to qualify to get flood insurance in some aspects. Maybe they don't want to use a mortgage to buy property, but the fact is if they don't, then they're not eligible for the flood insurance program. But by getting a mortgage, then they're eligible and they get the insurance, then they pay off their debt. It's crazy, but that's how they become eligible to get the flood insurance. Now, under the closing documentation that today we use, we actually went through some of this yesterday. According to the Consumer Financial Protection Bureau, in October of 2015, all our closing procedure changed. Prior to 2015, we used RESPA, the Real Estate Settlement Procedures Act, as our guidelines to close real estate transactions. Every state in the union used the same paperwork and the same process to close transactions. However, under the new laws, as we said the other day, the new TRID rules, T stands for Truth in Lending Act, R for the Real Estate Settlement Procedures Act, and ID was for integrated disclosure. And as we said, 7 days before the final closing, the lender gives the borrower, 7 days before, the lender gives the borrower a final loan estimate. The borrower then sends back an intent to proceed document, which finalizes, if not already, the aliens information we talked about. And then 3 days before the closing, lender sends out to the buyer and the seller the integrated disclosure settlement sheets to show where the money's coming from, where it's going, and all the settlement costs, so that when you go to a closing, there should be no major settlement costs having to be taken care of. Now, there may be minor things that have to be taken care of, like an unpaid water bill of $27. That's not a big deal. That can be taken care of at closing. But if it's major, it may require all new disclosure forms, delaying the closing for a good 3 days. TRID does not apply to HELOCs, as we said yesterday. Mortgages secured through movable dwellings, cash transactions, or commercial loans. But what applies to HELOCs and reverse mortgages are still the HUD-1 form, the good faith estimate, and the truth in lending laws. Under RESPA regulations, Section 8 prohibits against kickbacks, illegal payments that the IRS in the state of New Jersey does not see. You can't do that. And by doing that 3 days before the closing now, where you see the integrated disclosure, prevents that from happening. Section 9 prevents lenders and sellers from requiring buyers use certain particular title insurance companies. Most title insurance companies, by the way, are owned by attorneys and real estate professionals. Why? Because they're cash cows. What do you mean? Well, think about it. Today's property is being bought and sold quite often, and many transactions may occur over the length of the property's history. If there were any claims against title ownership, pretty much by now they should have already come forward. So the fact is, very few title insurance claims are being made today, so that when these title insurance companies accept a premium from a client, let's say it's $2,000, they put it in their kitty of money to spend if they have to, but most likely now when that house gets resold, the title insurance policy is canceled and the title insurance provider keeps that money as income. So you can see where owning a title insurance company could be very lucrative. And Section 10 requires that lenders are limited to certain limits when maintaining escrow accounts. Can't go above certain dollar figures anymore. TRID requirements require the closing disclosure be given 3 days before the closing to both buyer and seller. And if it's the loan estimate, again, remember it was 7 days before closing. And the borrower should compare their loan estimate to the closing disclosure, make sure everything is consistent. So title procedure is that at just before the closing now, the title insurance company does what's called a rundown search or second search of the public records. Why? To make sure that they know if anything changed from the initial title inspection, such as the seller adding more debt at the last minute to the property, which may not be disclosed if it wasn't recorded. Therefore, by doing a rundown search, they'll clear up any missed opportunities to collect money or any missed recordings of debts that may have been happened since the original search, so they can be included in the closing disclosure statement. The buyer has the right to an inspection of the premises before closing. It's called the final walkthrough. And that's where the buyer, along with their agent, go to the property and walk through it to make sure that what they're paying for is what they're getting. There's nothing worse than going through a walkthrough and realizing the seller didn't do what the contract said, and then you have problems at closing with settlements. Also, the seller is expected to execute an affidavit of title at closing, a sworn statement as to the validity and his authority to convey that title to the buyer and the validity of the title. And the seller must release existing liens on the property by offering payouts to those. So the seller has to call for payoff statements from the banks to make sure that at the closing, the proceeds pay off the loan so no liens follow the property. Sometimes properties close in escrow. The property I bought from the little old lady I told you about, we actually did a lease purchase option where I bought the house from her. She stayed on as a tenant for a couple months. But we also closed in escrow with $5,000 left in an escrow account with the attorneys, a third party. Why? Because at an in-ground pool, and the owner had claimed that it hadn't been working in 7 years and there was something wrong with the equipment. And since it was in the middle of winter, I couldn't do a pool inspection. So we kept $5,000 in escrow. So when the ground finally thawed out, the end of March, beginning of April, I hired a pool company to come in, drain the pool out, do a thorough inspection. Turns out the whole problem was because of a $7 valve was broken. So I had them replace that, clean the pool out, and fill it up with new water. And it cost me whatever the cost of the inspection and the filling up, plus the $7 valve. I didn't call for the escrow to pay me out. I just told them, give all the money back, because this lady needed it more than me. So just give her all the money back. I don't want to take $7 out of the escrow. And besides, I probably would have changed the valves anyway when doing the inspection of the pool. All right, so escrow is when you close with money held in an escrow account by a third party to take care of a problem that may or may not be real. And upon further inspection and discovery, the money will be used to pay for any repairs or requirements as a result. But after all conditions are met, agents disperse purchase price to the seller, this title company or your attorney, and then receive the deed from the seller for the buyer, and then record the deed and the mortgage in the public record to give public notice, constructive notice. So now comes the question about accounting on the closing documentation. Now, everybody usually gets upset at this point and goes, we got to do this, debits and credits, and oh my God, prorations and settlement costs. This is ridiculous. I got good at math. Hang on, guys. Here's the thing. In New Jersey, you don't do any of this stuff. You just have to know about it to pass the test, and then you can forget all about it. Typically, paralegals and title company employers are doing all this work so that you don't have to in New Jersey. In some states, agents are required to know about this stuff and do it, but not New Jersey, so we're not going to go any further than that. Now, Accounting of the parties' debits and credits. So let's just assume for a second here, guys. Again, I don't want to go too deeply into this because technically you don't really need even to know about this stuff except to pass the test. And then once you do, you can forget everything about it for all I care. Things work in the background. Things like what happens, and let's use an example here. What happens in the case where the seller has prepaid his yearly tax bill of $12,000 in advance for the entire year on January 1st. And the closing is going to be on July 15th. Well, there obviously has to be some sort of settlement at the closing because the seller prepaid the entire year's taxes. So for the accounting purposes of proration, they use the following concept: 30 days per month, 360 days in a year. Period. That's it. 30 days per month, 360 days per year. So now let's look at this. This roughly breaks down into $1,000 a month. Would you agree at $12,000 a year that it would cost about $1,000 a month? Okay, good. I'm saying you agree. $1,000 a month. Now, the closing's July 15th. So let's see, January, February, March, April, May, June are paid for by the seller prepaid, but so is the rest of the calendar year. However, he prepaid the entire year, but only uses up to July 15th. So technically, he used 1, 2, 3, 4, 5, 6.5 months worth of that $12,000 or $6,500. That means at the closing, the buyer has to give back as a credit to the seller $5,500 because he's taking advantage of the prepaid taxes for the half of July, then August, September, October, November, December, 5.5 months. So at the closing, the buyer would be showing a debit of $5,500 with a credit of $5,500 going back to the seller to make that a total of 12 grand that he prepaid. This is just an example of how a proration works. Now, before I go any further, guys, let me just understand. There's going to be questions, I know that. But guys, again, only stick to the topics being presented and forget about the what ifs. Was there any questions or comments? The agents for the closing entity, whether it's the attorney's agents or the title company's agents, not the real estate agents. So I think you read into something, Gary, that wasn't there. What do you want me to repeat, Anya? Credit to the buyer is credit to the buyer is due immediately at closing. That's where it's taken care of. Yes. So exactly, the realtors do a closing. Collect checks. Into July is 7 months and 15. Well, hang on a second. January, February, March, April, May, June, July is 7 months. No. January, February, March, April, May, June is 6 months, and half of July is 6.5 months. What do you say about the buyer bringing $5,500 to closing? Can you repeat that? Again, that was the proration settlement that we did in the math example. So realtors don't have to do any paperwork, not at closing. Regarding the loan estimate and closing, I guess, disclosure at minimum, is that 7 days or 10 days in total? 7 days total. 7 days for the loan disclosure, the loan estimate, but then 3 days before closing, the integrated disclosure. 7 days in total. Was there anybody else with a question? Gary? No? Oh, do realtors have to be present closing? No. You moderate. All right. So accounting at the closing may involve credits and debits, but the paralegals and the agents for the title insurance companies will be doing all that work behind the scenes. You don't have to. Prorations could include rent monies. Think about it. The closing is on July 15th. The seller collected all the rents on July 1st, prepaid for the month. That means at closing, the seller must credit the buyer half month of all the income he received on the property. He must also transfer all the security deposits to the buyer, so the security deposits will be a credit to the buyer. Taxes paid in advance, well, then that buyer has to give credit back to the seller for the part he didn't use. That's the example I was using before. So what kind of closing expenses are there? Well, there are broker's commissions, and usually it's the seller who pays, but sometimes we get the buyers to pay too. There's attorney fees if they hired one. There's recording expenses. There's a realty transfer tax. And on page 363 is the very complex, convoluted mathematical equations used to calculate transfer tax. If you just said to a seller it equals roughly a little less than 1% of the selling price, that's usually adequate so they can prepare for the fee at closing. But if they want you to figure it out, you can use this formula. Always use this book, guys, as a reference. You know, put this on your desk, put it in the back of your car or something, but always use it as a reference. You may never know when you're going to need it, but if you do, you have it, and you can calculate this transfer tax out. So transfer taxes are going to be an issue at closing. The realty transfer tax is always paid by the seller in New Jersey. The buyer doesn't pay it, the seller pays it. Title expenses, if a deed has to be drawn up and conveyed, then the attorney who draws it up is going to charge for the services, and usually the seller pays for that. Any loan fees the borrower has to pay for now has to be accounted for, or you may have the option of maybe incorporating them into the financing package. Some of these costs can be included in the financing as closing costs. Some cannot. Tax reserve insurance fees, those have to be paid as escrow accounts to the bank. Any additional mortgage related fees, appraisal fees, survey fees, prorations, those again, all have to be figured out at closing. Prorations are adjustments. Expenses fairly divided between seller and buyer, and accrued items are credits to the buyers, and prepaid items are credits to the sellers. So in that example I used before, that $5,500 overage that the seller paid in taxes for the year gets credited back to him at closing. So the seller gets back a credit for the prepaid items. Rents adjusted to actual number of days in a month. So if you have rents on a building, those would be calculated at the exact number of days given to the seller, exact number of days given to the buyer. Security deposits are transferred to the new owner at closing as a credit. Now, preparation of closing statements. Items credited to the buyer are typically unpaid principal balance of outstanding mortgages when the mortgage is being assumed by the buyer. In other words, the buyer is assuming the debt of the seller, so it's going to show up as a credit to the buyer at closing that he's taking on that debt. Interest on existing assumed mortgage loan not yet paid is accrued and credited to the buyer. Buyer's earnest money kept on reserve, buyer's credit. Unearned portion of rent collected, buyer. Earned janitor salary if there is, buyer. Tenant security deposits, buyer. Credits to buyer. Purchase money mortgage if seller is financing, credit to the buyer. Same thing, seller financing. Unpaid water bills, credit to the buyer. And real estate taxes in arrears, credit to the buyer. In other words, they haven't been paid. Therefore, the buyer's going to have to pay for them. The seller must give them a credit at closing for that. Items usually credit to the seller are the sales price. Any personal items like fuel oil that is on hand can be credited back to the seller at closing. Insurance and tax reserves when outstanding mortgages are being assumed by the buyer. Refund the seller of prepaid water charges and some expenses like taxes or whatever. And portions of real estate taxes paid in advance, again, credits back to the seller. And at the closing, the attorneys, if there are attorneys, have the authority to close the transaction, or if you're not using attorneys, title companies can close it. They have the authority to close the transaction. They usually then would record the documents as well for the buyer, whether it's the title company or the broker or the attorney. The broker's responsibility, someone asked before, literally show up and collect the check. However, I'm going to caution you, and that's what a lot of people say, oh, you're just here to collect the check. Just remember. Now, just an example, whenever I took a listing or worked with a buyer, I told my clients, we're going to be a team. Together, we're going to achieve selling your house or helping you buy a house. And I will be with you through thick and thin. I'm your agent. I will not leave you. I need to build up that level of trust and dependency that they always can turn to me for help. So I told them, every one of them, I'll be at your closing if you want me to be. And most people said, you don't have to, but if you'd like to, yeah, you're welcome. Except this one little old lady. If she was 80 pounds soaking wet, I'd be amazed. She was about 75 years old, a widow woman, and she was always a little nervous about things. And I told her, would you like me to go to closing with you? She said, oh, could you do that for me? She just needed someone to be with her. So I went to the closing with her, and for the next hour we sat there, her hand was on my arm, and whenever she got tense, she would squeeze my arm a little bit. Well, as things went over, her level of tension rose, and she squeezed. And she squeezed and she squeezed until my eyes were about the size of dollar bills. And then it was over. She let go, and oh God, the blood returned to my fingers. Woo-wee. And for about 2 weeks, I had nail marks in my arm. That's how tightly she squeezed. At the end of the closing, I said, ma'am, are you okay? She goes, I just have to let you know. If you weren't here, I don't know how I could handle this kind of tension and pressure. Believe me, guys, closing on a real estate transaction is a very emotional thing. For her to tell me that assured me that my presence was appreciated. I don't just show up for a check. I show up because I tell my people, I'm here for you through thick and thin. If you want, I will show up at the closing. And a lot of people say yes, and I would show up just because maybe, like her, she needed someone with her just to give her support. God bless that little old lady. She was a great kid, man. I tell you, what a great deal that was for me, too. So understand, guys, broker's responsibility is you're there to pick up a check is what you're there for the broker to cash. And once he cashes it, then he pays the salespeople through the proceeds within 10 days of his getting. But at the same time, I'm there for emotional support. I want to make sure my people are aware that I'm still there. That's called making customers for life. And believe me, if you're only in it for a deal to make quick coin and you're done, then good. Make your quick coin and be out of here. But if you want to last in this business, guys, you're going to make clients for life. And you're going to do the little things that maybe nobody else does. Just to show up to be with someone could be everything to them. So understand, guys, your support, your moral support, your presence can mean a difference to some folks, especially in a closing process where emotions and attitudes tend to get a little high strung. So sometimes you just have to be the calming voice. But at the closing also, all reported sales are reported to the state of New Jersey for tax purposes. So at the closing, the seller's attorney has to make sure that the proper tax payment for his transfer tax and or exit tax goes to the state of New Jersey. For the buyer's attorney, if they're buying a property of more than $1 million, he must make sure that the buyer's luxury tax of 1% on any property of $1 million or more gets paid in the state of New Jersey. And the IRS knows and has copies of all this for tax purposes of capital gains, etc. So you have to report all these sales, not you, I'm talking about the closing agents, send these reports off to the state of New Jersey and the IRS for accounting purposes. And you close the transaction, and we're done with our discussion on that. So before I pull up the review questions on this chapter, does anybody have any final comments or questions? And Gary, once again, no, you don't have to be. Transfer tax, 1%, little less than 1%. Security deposits go to new owner in the form of credit. Yes. Is exit tax same as transfer? No. Transfer tax and exit tax. If you're leaving the state of New Jersey when you sell your house, you have to pay the state of New Jersey an additional 2% sales price tax because you moved out. Luxury tax is applied to a buyer if he buys property of $1 million or more at 1% of the sales price. Oh, thank you, Christopher. I appreciate that. Client just asked me to go closing tomorrow. I told him I had class. Now I feel a little guilty. Well, what time's your closing, Robert? If it's after 12, remember, we're only going to be here till 12 o'clock tomorrow. Maybe 12:15, but that's about it. After that, if they have the closing afternoon, you can go. It's only a half day. Oh, thank you, guys. I appreciate the comments. But now, since I don't see any more questions, hang on. If a client is renting after closing, do they have to pay an exit tax? If they're staying in the state of New Jersey, then no, they don't. Well, actually, you do. Okay, why don't I just stop the class here and explain exit tax? I do present this in another class, but since it's also covered here, let me explain. I'm going to pull up the whiteboard. Let's say a $2 million property is being sold. Now, there's plenty of $2 million properties in the state of New Jersey. At the closing, the seller and the buyer now both have expenses. Based on a $2 million sales price of less than 1% of the sales price is the transfer tax. Again, a little less than 1%. So let's say it's $17,500. That's a little less than 1%. 1% would be $20,000. So they have to pay the state of New Jersey $17,500. If their seller is moving out of state as a result of the sale, that's the exit tax, of which it's 2% of the sales price, or $40,000. So the seller now has to come up with $57,500 when selling their house and moving out of state to pay for transfer and exit tax. Since it is a sale price of over $1 million, a buyer is required to pay a 1% luxury tax, or $20,000. Which means, together with the 57, the state of New Jersey on the sale of a $2 million property realizes a $77,500 income in fees and taxes from the sale of one $2 million property. Now, this exit tax is what everybody's bent on, right? Who pays it? The seller does. Under what conditions? If he moves out of state after selling his property. However, if he stays in the state of New Jersey, they still collect it at closing. But so long as that person files their income tax and pays income tax in the state of New Jersey in the calendar year following and stays on as a resident, then they can get the 2% back from the state. Now you can see how the state of New Jersey is so messed up. First of all, there's a lot of $2 million properties being sold, which means the state's collecting on average $77,500 from each. Where the hell is all that money? It's a valid question, and every time I send a letter to a legislator or an assembly person, I get crickets as a response. No one wants to talk about it. It's a serious issue. Again, I have bones about the tax structure in the state, and I obviously don't hide that. But for sake of argument, guys, just understand that there are taxes to be paid when you sell your house. The seller has to pay transfer tax. If they're leaving the state, 2% exit tax. If a buyer's buying a luxury property of $1 million or more, he's required to pay a 1% luxury tax to the state of New Jersey. So on a $1 million purchase, a buyer pays $10,000 to the state of New Jersey just to buy a $1 million property. It's ridiculous, but that's the law. So now, I hope I explained it in a quick and dirty way that you got the understanding of what it is. How does the state know if you're moving or not from exit tax? Well, first of all, you have to report to the IRS what your forwarding address is going to be, so in case they have any questions, they can contact you. So they'll have a record of your moving to address. How does state, okay, so can a flood zone be determined during a home inspection? Well, to look for a flood zone, you have to go to a FEMA map and look at it. Yeah, New Jersey knows how to make money. The problem is they know how to spend money more than they know how to manage money. Can you make two separate transactions to keep both of them under 1 million? No. And in fact, any transaction that hovers around the $1 million mark is going to be inspected and audited by the state of New Jersey to see if the owner actually tried to circumvent the 2% exit tax and the buyer's luxury tax. So they're going to audit any closings that hover around the $1 million price range. All right, so I don't see any more questions. Let me moderate and pull up the questions for review for the chapter, and we will be getting out of here soon. So let me pull up chapter 21 review questions and start with our review of chapter 21. Number 1, public records may be inspected by who? Who can look at public records? I love doing that. Who can see public records? Gary, no, because you have to file taxes as a resident in the state the following year to keep the 2%. So you can't just say, I'm living on others, but you have to actually pay taxes in the state. So public records may be inspected by 92% of you are correct, answering A, anyone. Right, we live in an open public record society. Number 2, the date and time a document was recorded establishes which of the following? The date and time a document was recorded establishes which of the following? And from those responding, 62% of you are correct, answering A, priority. Yes. Number 3, an instrument affecting title to a parcel of real estate gives constructive notice to the world when it is filed with the All right, so I just typed in the unclaimed property web address again. If you didn't have time to copy it down before, now's a good time just to highlight and copy it. This location of your homework is recareercenter.com/homework. If you could give us a review, as we've been asking, please, guys, we live and die by these. If you could give us some reviews, we'd appreciate it. Help us know how we're doing. recareercenter.com/review us. Or if you want to reach out to me in a public or a private way, you can always reach me at tjensen@recareercenter.com. So an instrument affecting the title of a parcel of real estate gives constructive notice to the world when it's filed with the county recorder. 67% of you correctly answered that. Yes. Number 4, in New Jersey, no deed may be recorded unless oops, did I misspell something? Yeah, I did. Let me amend this. Sorry, guys. Career. RECareerCenter.com/review us. Okay. There we go. Sorry, misspelled. All right, so in New Jersey, no deed may be recorded unless D for dog, all of the above occur. Has to be acknowledged, transfer tax has to be paid, and full consideration must be mentioned in the deed of conveyance. And D, then all of the above must occur is correct. Number 5, the principle of caveat emptor states that if a buyer buys into a title problem, the fault lies with the And from those who did respond, 81% of you correctly answered A, the buyer. Caveat emptor, let the buyer beware. Number 6, which of the following is not acceptable proof of ownership? Remember, there were 4 evidences of title. Which one's not one of those? Which one is not like the others, right? Mhm. Which of the following is not acceptable proof of ownership? Well, the torn certificate is, title insurance policy is, abstract and lawyer's opinion is, therefore by process of elimination, D, 60% of you had to correct the deed signed by the last seller, is not evidence of title. Remember, what if they're unscrupulous and are using a quick claim deed and they actually have no ownership interest? Then the deed means nothing. So D is correct. Number 7, in locations where the abstract system is used, an abstract is usually examined by the in locations where the abstract system is used, an abstract is usually examined by the, and 80% of you correctly answered D, attorney for the purchaser. Because remember, he gives his opinion, attorney's opinion of title after reviewing the abstract. Number 8, proof of the kind of estate and liens against a parcel of real estate can usually be found through proof of the kind of estate and liens against the parcel of real estate can usually be found through And about 65% of you correctly answered C, one of the four evidences of title. Remember, a recorded deed only tells you about the conditions of the deed, not about any liens about the property. The abstract would report about the liens and the debts on a property. So C is the correct answer. Number 9. A fee title insurance policy generally defines the property owner, defends the property owner against problems arising from a fee title. Let me correct the misspellings. A fee title insurance policy generally defends the property owner against problems arising from well, for some reason, I'm going to have to stop you here, guys. Need to stop here. The answers offered in number 9 only have the first two answers correctly listed here. They don't have the other C and D as it pertains. What they did is, if you look, they took the answers to number 10 and put them up in chapter 9. Unfortunately, I have to interject here. Answer to question 9 is C. In your book, if you're looking there, the answer is forged documents would be C. And unfortunately, we have to get our people on this and correct that stuff. And I apologize. I just noticed it right now. This is unacceptable. Unfortunately, Dearborn, as you know from looking at the answers in the textbook, is sometimes wrong about some of the information. So unfortunately, let's skip question 9. If you're looking at your book, which you probably are, then C, forged documents, would be the correct answer. Number 10, if a property has encumbrances on it, then what? If a property has encumbrance, it, D, can be sold if the buyer agrees to take subject to the encumbrances. 90% of you got it correct. D, correct. Very good. Number 11, mortgage title policies protect which party against loss? Good question, right? Well, I actually gave you the answer today when I discussed it, and I actually mentioned it maybe 3 or 4 times. So let's review. There are 2 types of title insurance policies. One is a fee policy that the buyer gets, and the other one is a mortgage policy which the lender gets. So 52% of you correctly answered C, lenders get mortgage title insurance policies. Number 12, the seller is frantic because she can't find her deed and now wants to sell the property. The seller And again, from those who did respond, about 80% of you correctly answered C, does not need the deed if it had been recorded. You can just go down and get duplicate originals from the registrar. Number 13, flood insurance is required for mortgaging property if it is and 95% of you got it correct, B for boy, on a flood-prone area on a special map. Correct. Number 14. I guess you need to, let me see if, identify one of the rest requirements. Oh, okay, so of the following, which one is a RESPA requirement? That's what it's really asking you. So which one is it? Good. Looks like a number of you guys have it. Good. I'll wait. Oh, excuse me. And from those who responded, which was less than average, 70% of you correctly answered D. RESPA prohibits kickbacks or unearned fees, but does not include fee splitting between cooperating brokers. That is correct. It prohibits kickbacks, but still allows brokers to split commissions with competing brokers. Yes. Number 15, a mortgage reduction certificate is executed by, signed by, a mortgage reduction certificate is a statement of debt, and it is required to be signed by the borrower at closing. So who requires it? Yes, the majority of you getting it. And 81% of you correctly said C, the lending institution. Very good. Okay, here comes a math question. No, not math. A buyer of a $150,000 home has paid $2,000 in earnest money and has a loan commitment for 70% of the sales price. How much more cash does the buyer need? I'll work the numbers with you. I'm going to give you a few seconds to figure it out. There's only one more math question in the review, so don't worry. It's not like it's a big part of your exam. There are going to be math questions, guys. So learn how to do math if you haven't already. And chapter 22 is for your perusal to go through. And I suggest if you're rusty on math, you go through that and learn. So anybody want to answer this? So let's do the math. The majority of you who have answered have got it correct. So let's do the whiteboard. They're buying a $150,000 home, right? $150,000. Okay. They're required to put 30% down. So times 30% means they have to put $45,000 down. However, they already deposited $2,000. So how much additional cash do they need? $43,000, and about 80% of respondents who answered that got it correct. Is 43,000 is B for boy. Again, real quick, $150,000 purchase, 30% down payment, $45,000. They already put $2,000 on deposit, so how much more cash do they have to bring? Only $43,000 because they have $2,000 on deposit. Number 17, at the closing, the seller's attorney gave credit to the buyer for certain accrued items. These items were at a closing, the seller's attorney gave credit to the buyer for certain accrued items. That means debts. These items were bills relating to the property that the buyer will pay. B for boy is correct. Number 18, the earnest money left on deposit with a broker is a the earnest money left on deposit with a broker is a 64% of you correctly answered B, credit to the buyer. B for boy. Here's a math question. Oh boy. There's actually another one after this. A building was purchased for $285,000 with 10% down and a loan for the balance. If the lender charges the buyer to discount 2 discount points, not TO, TWO, how much cash did the buyer need to come up with at closing if the buyer incurred no other costs? I'll do this with you. Okay. All right, let's do the math. So, but just by looking, looks like about 55% of you are correct answers, so let's do the math. So you're buying a house for $285,000. Okay. Now, you're required to put 10% down payment. So times 10% is $28,500 you're out of pocket so far as down payment. But it also says you have to put 2 points down in financing. So 90% of 285, the loan amount is equal to $256,500 because 285 minus 28.5 is 256.5. So that's how much the loan amount is for times 2%. That equals $5,130 for a total out of pocket of $33,630, which was C, and 60% of you guys got that one correct. Let me just do the math one more time. You're buying a house for $285,000, putting 10% down, so you have to put down a minimum of $28,500 so far. But you're also required to put 2 points down as a condition of the loan. The loan at 90% LTV of $285,000 would be $256,500 minus times 2% is $51,30. $51,30 plus $28,500 equals $33,630. The math checks, and the majority of you were correct. Number 20. This is the same principle I use when explaining proration. Let's look at it. And I'll do the math with you. The year's town, county, and state taxes amount to $3,600 and have been paid ahead of time for the calendar year. If closing is set for June 15th, which of the following is true? Remember, 30 days per month, 360 days per year. How is the proration recorded at closing? So obviously we're having a little trouble here, so let's go to the board and figure it out. Or as Warner Wolf said, used to say, let's go to the videotape. Anyway, so here's the situation. You prepaid your year's taxes for $3,600, and it's good for, what, 3 years, right? Let's see. Yep. And the years, okay, it's the years ahead for the calendar year, $3,600. So think about it. There's 360 days in a year. So 3,600 divided by 360 equals equals $10 per day in charges. That's the first part. So if I then say $10 per day is the cost of the insurance, and the closing is June 15th, then I have to figure out at $10 a day how much of a credit and how much of a debit is due who. So let's look at it. The seller prepaid the year's taxes, so he used January, February, March, April, May, and half of June. So he had 5.5 months that he got a benefit out of prepaid taxes. That means the seller gets the remainder of the year, which is 6.5 months. That's easy, right? Well, if $3,600 or $10 a day times 30, that means $360 a month. So 360 times 5.5 is $1,650, and 6.5 is $1,950. So together they add up to $3,600. Good. So what happens is this. The seller used 5.5 months, $1,650. The buyer gets the benefit of the prepaid $1,950. Therefore, at closing, the buyer must be debited the $1,950, and a credit of $1,950 goes back to the seller. So together, that means the seller would have spent and gotten back a total of $3,600. Where the buyer has to credit the seller for that amount, he's got to be debited the same amount. So again, $1,950 debit to the buyer, credit to the seller. Same thing. And from those who responded, about 49% of you correctly answered that. One more time. Let's say instead of dividing by day, we did it divided by 12. That means it's $300 per month. At 5.5 months, The seller got 1650 use out of the 3600, which left 1950 for the buyer to use. Since the buyer's getting that benefit, he has to credit back to the seller 1950, and it will show up as a credit to the seller, debit to the buyer. That's how it's solved. All right, moving on. Number 21, under TRID rules, what is the time frame for a lender to provide the closing disclosure to the borrower buyer? Oof. Under TRID rules, what is the time frame for the lender to provide the closing disclosure to the borrower buyer? And from those who chose to respond, which again, this seems to be dwindling, but I understand. 80% of you correctly answered A, 3 business days before the closing. Yes. Number 22, the seller collected rent of $1,000 payable in advance from the attic tenant on June 1st. At the closing on June 15th, at the closing on June 15th, 85% of you got it correct. The seller owes the buyer $500. C, because he pre-collected the rent for the month. He has to give the buyer his fair share at closing. The seller owes the buyer $500. 23, security deposits should be listed on the closing statement as a credit to the, it's in your textbook. We did go over it. Okay, good. From those who did respond, about 80% of you correctly answered A, to the buyer. It's money the buyer put on deposit with his attorney or his realtor. Those are the deposit monies. They belong to the buyer. Therefore, at closing, it shows as a statement as a credit to the buyer. 24. An amount that one party owes to another and must pay at closing is an amount that one party owes to another and must pay at closing is and from those who responded, 2 out of 3, 66% got it correct. B, a debit. It's a debit. Number 25, an amount entered into a person's favor is referred to as a And 97% of you, that's one of the best answers in the whole day. 97% of you got it correct. C, it is a credit. And then finally, last question, when a realty transfer tax is involved, who of the following is responsible for the payment? Who pays the transfer tax is what they're asking. And okay, so that's it. So it looks like, and good, 80% got it correct. C, the seller pays transfer taxes, always. All right, good job today. I'm going to tell you right now, for what I'm seeing, it looks like about 65% of you are ready for an exam. At least 65% of you are ready for an exam. Other than that, tonight, your homework assignments are chapters 19, 20, 21. They can be found where I just typed in recareercenter.com/homework. You can pull up those chapters and fill them out. They're for your edification. You don't have to hand them in. And then tomorrow, this is what's going to happen. At 9 a.m., we're going to go over our homework, 19, 20, 21. Then we're going to start our entire book review. Whether you've been here for the required time or not, you still are required to attend a review class, and those are hours that count towards your class requirements. Whether you participate or not, that's up to you. And I'm going to tell you, a lot of people come just to listen and not participate. That's up to them. I think by participating, you'll build your body of knowledge much stronger. So I will be asking questions of everything in the book. You are allowed open book, open notes to do any research you want. You're going to have 1 minute per question to respond. I know that sounds unreasonable, but I'm going to put the screws to you. I want to see what you're made of because I have to prepare you to pass an exam. So come tomorrow with lots of caffeine in you. Get juiced because this is a practice of what a test might be like. You can use your book. You can use your notes for review. It's up to you. So if there's any additional questions, you can stick around. I'll ask